Hello and welcome. My name's Rachel Browner, and I am with our OneOp Lifespan Caregiving team. It's my pleasure to welcome you to this direct to learning session on understanding service animal rights when the law gets rough. Thank you for joining us as we continue our partnership with the Department of War and the U.S. Department of Agriculture to expand the readiness, knowledge, and networks of the professionals supporting our military service members and their families. The views expressed in this presentation do not necessarily reflect the official policy of the Department of War, U.S. Department of Agriculture, U.S. Government, or OneOp, and the mention of any entity or product is for informational purposes only. Please note that the slides and resources are available for download on the D2L page for today's session. I'm going to be covering continuing education information at the end of the program, so please stay tuned at the end. So if you're interested in receiving continuing education credits or a certificate of attendance, I'll cover that at the very end. I'm excited to introduce Jeanette Vaughn as our presenter for this D2L. Ms. Vaughn is joining us from Disability Rights Texas, which was really formerly Advocacy Inc., and is currently assigned as a senior attorney on the CAPE team, which handles disability issues and employment and accessibility. Since 2012, Ms. Vaughn has handled cases involving discrimination against service animals and handlers, beginning in cases involving a combat veteran who was denied access to a local business. Before joining Disability Rights Texas, Ms. Vaughn was the Civil Division Chief, the Juvenile Division Chief, and Narcotics Prosecutor for the Lubbock District Attorney's Office. Subsequent to her time as the Assistant District Attorney, she was in private practice for 12 years, working primarily in the areas of criminal, family, and employment and civil service law. Much of her practice involved representing police officers and firefighters in employment disputes, including the case memorialized in a book called Substantial Evidence. She's also been an adjunct professor for Texas Tech School of Law, the Wayland Baptist University, Lubbock Christian University, and the South Plains College, teaching courses in law, sociology, and communications. Ms. Vaughn has a BA degree in communication and a BS degree in criminal justice from the University of Texas at Arlington, and she's obtained her doctorate of jurisprudence degree from Texas Tech University School of Law.
Hi, we're here today to talk about basically a general overview of service animal law, at least up until the date of this presentation. It changes frequently. There's new cases coming out. But we're going to cover a few of the cases and some general topics. I'm an attorney with Disability Rights Texas, and I handle a lot of service animal cases, both for veterans and combat veterans and people that do not have military experience. So we're going to discuss some of those different situations and some of the cases that are sort of fact specific in nature. Generally, we're going to talk about the difference between a service animal and an emotional support animal. Sometimes people use the language of assistance animal as well. Each of those sort of has developed its own meaning over time, but the two that are very clear and need to be clear statutorily are service animal and emotional support animal, because they make a difference in how the law applies to the dog being in a public place. The laws that we're talking about or are allowing a service animal to assist somebody with a disability, and there's different perspectives for being in a public access, what I call public access, so being in grocery stores, restaurants, nightclubs, things of that nature. There's different rules for housing, some for employment, also different rules for dogs that are in training to be service animals, but they're still getting training. And then there's a question about direct threat that's going to come up in some of the cases that we'll discuss and explain what those are and how the courts have handled that in some situations. Here's some of the areas that we're going to look at today specifically. allergies and fear of dogs, that frequently comes up with a service animal issue as a defense by the business or the office that does not want to allow the dog to come in. We're going to look at dogs and training and how they're affected, how dogs have been treated when they're taken into restaurants. A little bit about police failure to respond, because that's not really been a clear area when they show up, but they do not make the business allow the service animal. We'll look at that a little bit. How it's handled in transportation settings. So that includes both air carrier travel and could be a local bus system or a transit system in your town that might be affected on that. Hotels and motels are a special category that frequently comes up. There are some rules for schools that are in K through 12, kindergarten through 12th grade, through high school, and then different applications apply for colleges and universities. There's a whole separate law that applies in addition to ADA when you're talking about housing. Medical settings carry their own unique issues because of some of the places being sterile. And then a little bit about employment, which falls under a different category in the statute than all of these other categories, these other topics. In 2011, the DOJ changed the definition of service animal. It was really sort of wide open and a lot of different terms, and people thought they knew what the terms were, but not everybody agreed on what the terms were. Because of the problems some people were having with people taking their pets out in public, or a dog that was identified as an emotional support animal, the DOJ put in a very specific definition in 2011. And basically, it is a canine, it has to be a dog that is individually trained to perform tasks to help an individual with a disability alleviate symptoms of their disabilities. So that carries a lot of meanings to it. Well, I should add that there is one minor exception in there for a miniature horse. Occasionally, we're not going to talk about that much today, but the miniature horse is an exception. You may wonder why anybody would have a miniature horse for a service animal. Actually, sometimes they are actually the best. Number one, they can be smaller than some of the large dogs, but they tend to live longer. And they're stronger if somebody has a mobility or a balance issue. So some people prefer to have a miniature horse for that purpose. So they are allowed under ADA in some circumstances, with some changes or modifications that has to be practical for the situation that it's in. But the dog or the horse has to be individually trained to work or perform tasks for the person with the disability, and to basically alleviate those symptoms of the disability. The general rule on access changes on where you are. So Title II covers government offices, state and local government offices. So that would be, your state capitol, city hall, a county courthouse would all fall under Title II of the ADA. Title III deals with public accommodations. And public accommodations are the things you may normally think of where you're going to see a service animal: a grocery store, a restaurant, a movie theater, a doctor's office. It applies to lawyers' offices and doctors' offices. It could apply to your CPA. It could apply to a lot of professional offices in addition to retail stores. But retail stores and even public parks can be falling under that. Public parks are probably more under Title II unless they're privately owned. Public access no longer applies to an emotional support animal, though. An emotional support animal can provide some assistance to the person with a disability, but that there's no requirement that an emotional support animal be individually trained to perform a task. So that task factor becomes critical when you're deciding whether the dog falls under the protections of the ADA to go out in public with the dog handler. If it is just an emotional support animal, they provide comfort, in some ways the way a pet would, but usually there's been a psychologist, a counselor, or a medical doctor who has said, I think you would benefit from having a dog in your house and a dog to be with you and provide you some kind of emotional support. So Previously, those were allowed in other areas. They are still allowed in housing. They're no longer allowed on airplanes, which we'll discuss. But that dividing portion in 2011 made it very clear that they do not have the same rights to public access as a dog that's defined as and meets the definition of a service animal. Several different statutes apply. We're going to talk about ADA and some other statutes as well, but here's the breakdown if you're looking at a particular thing or you want to do more research on it when you have an issue that you're working with. Title I of the ADA is the employment statute. It covers employers with 15 or more employees. So a small mom and pop business with just 3 employees is not actually covered by the ADA, may be covered by the state law in any given state, but it's not covered by the ADA. And there are some special rules about whether it can apply to a state agency because of governmental immunity. But generally, Title I is the place that we look to when the issue involves a service animal request as a job accommodation at an employment location. Title II of the ADA covers state and local governments. Like I said, that can be city, county, or state. Title III is public accommodations generally, and there's regulations that implement that. Those are cited there. I'm not going to go through all of the individual regulations, but you can check those with that site and pull up specific guidance or rules that have been put in place under those 2 categories. The similar state statutes are individual, and whatever state you're in, you really should check that if you're looking at what rights apply to an individual person to take their dog out in public. I've put a site in the PowerPoint that includes a link to go to animal law info, and it has a breakdown by all 50 states. You can pull up animal laws, not just service animal laws, but animal laws generally for each of the states by just going to your state and clicking on it. So that'll give you some information about whether your state law applies. One of the reasons that's important is the ADA doesn't provide for damages if the ADA is violated by kicking somebody out with their service animal. There's not a damage provision in that. You can get injunctive relief and you can get attorney's fees, but you can't get damages for the individual who was actually harmed. That may be different in your state statute. In multiple state statutes, there is a civil penalty or a damage option available in the state statute. Some of the statutes, including Texas, where I'm based, has a criminal penalty as well. And the statute may have a penalty for being kicked out because of the service animal. It may also have a penalty, civil or criminal, usually just criminal, for faking a service animal, or what people refer to as faking a service animal. So claiming that an emotional support animal is a service animal when it's not, claiming that a pet is a service animal when it's not. And that, that's terribly easy to do anymore because anybody can go online and order a vest that has patches for service animal, or they can add vests to it. And there's no filtering process for that to identify that the dog actually is trained as a service animal. So there's been problems with people taking their dogs out that are not, and the state statute may be where you want to look for that to get damages. Additional statutes that we'll talk about in some of these cases are Section 504 of the Rehab Act. That really was the precursor to the ADA. It was originally designed to keep federal entities or even a private business that received federal funds, federal contractors, anybody who received federal funds, from discriminating against people, which makes sense. I mean, they're funded by tax money. If they're funded by tax money, they should not be discriminating against the people who are paying the taxes. So 504 went into place first. That's usually combined and analyzed a lot with ADA because it set some of the early precedents for that. But you'll find that it may not apply where you normally think of. It's not just a contractor that the government hires to handle their IT work. It's frequently coming up with colleges and universities, even private colleges, because they accept federal financial aid for students. So you have to kind of track who's getting the federal money to see if that applies. The Fair Housing Act is specific to housing and has different rules, and we'll discuss later specifically one specific rule, and that's that this is the one statute remaining where emotional support animals are still covered and allowable under the statute. Your state may also have a similar statute. I've included one in here, but you can check that link to see if there are other state statutes that in your state that are the equivalent of the Fair Housing Act. So many states have their own Fair Housing Act. It may be under a property code, it might be under some other label under a code, but it is the equivalent of a Fair Housing Act under state law. Air carrier access deals with commercial airlines. So you're going to find sometimes different rules depending on what happens with your service animal. Does it involve the airline or does it involve the airport? If it involves the airport, you're probably under Title II. If it involves the airline, you may be under Title III, but you also are under Air Carrier Access Act, which is going to have a lot of specialized rules, especially now. Here are some examples. The examples that they list in the regulations for tasks that can be performed are just that. They're just examples. They're not inclusive. You could have a dog that's trained to do something specific that maybe has never come up before, and it's not on the list. But there are examples listed, and they're good for training staff to kind of get an idea what it might be. So it's not just what they're looking for. Sometimes if you're training staff, they may think of a service animal only as being a guide dog. That's what they know. That was kind of the early service animals that were trained, that people recognized. So they may need to know that there are other tasks. Guiding somebody who's blind is a valid task that's frequently used, but it also can be used to alert somebody who's deaf. The dog will alert to people nearby. It might alert to a doorbell ringing or the sound of a car as somebody's passing the street. There's different things the dogs can be trained to alert to. Pulling a wheelchair is not uncommon, especially if the dog is a larger dog, and it will assist somebody with a manual chair with not having to pull completely, or who doesn't have the body strength to use a manual chair without some assistance. Alerting and protecting persons with seizure disorders or diabetic episodes is more and more common to me now than it was even 10 years ago, and very useful. I've actually worked with several veterans who had traumatic brain injuries, and those brain injuries led to seizure disorders as a continuing problem that they had when they came back to the States. So that's a pretty common one that I have to deal with. It can be a simple task as reminding people to take their medications, or a task to calm. If somebody has PTSD, they have anxiety disorder, they have panic attacks, then they may have the dog perform a task to calm. The difference is there has to be a task for that, for the dog to be out in public. They have to be trained to complete the task. So if they are just calming by their presence, that's an emotional support animal. If they're calming because you can pet them, that's an emotional support animal. And they're not allowed to go out to the grocery store with you or the movie theater with the handler. If the dog is trained to perform a task, and you may not, as an outsider, recognize that's a task, but they can train the dog to perform a task that helps to alleviate those symptoms or helps to give them prior notice before the onset of a seizure or a diabetic episode. A diabetic trained dog will recognize if glucose levels are going too high or going too low and can notify the handler beforehand. I've seen people talk about their dog letting them know 15 minutes before their actual glucose monitor goes off. So the dogs can perform in a way that even mechanical devices and technology cannot perform because of the way they pay attention. To calm, the task, like I said, may not be visible to you. I've seen that because it may start lower. The dog may at first just start monitoring, looking at the handler. Then the dog may stand up. If the handler doesn't pay attention to them or doesn't acknowledge that they've gotten the message from the dog may go over to them. And it progresses like that to where maybe the dog's touching. And the last I've seen is if the dog starts pressing on a leg or licking a hand and the handler does not respond, then I've seen dogs trained to like literally jump in their lap in order to get their attention and force them to pay attention. They may also be trained to be doing something that you think, looking at it, looks like the dog is maybe misbehaving in some way because they're pulling on the handler trying to get him away. And that may be part of the task training to get the handler out of the situation that is creating the anxiety or leading to a trigger of a memory that's related to PTSD. Service animals are not pets. I hear all the time, no pets allowed. We don't allow pets in here. Service animal is a medical device. It is not a pet, even though it's a dog. It's not a pet. So all those no pet policies don't apply. Anybody that has a no pet policy is required under the ADA to modify their policy to allow a service animal. They can still say no pets allowed. They can still say no emotional support animals allowed. But a trained service animal, they cannot exclude because it's a dog. In places where the public is allowed. Like I said, when we get to some of the medical stuff, if it's in a very sterile area, I mean, obviously your dog is not going to be allowed in an operating room. That's where it's a very sterile area. But in other areas, they are because they're not considered pets, even if there's a no pet policy. I have a note in the slide about the VA prosthetic program. If you are working with a veteran, especially a veteran who has service-connected disabilities that are requiring the use of the service animal, or maybe not even requiring it, they might still be able to get under that. It used to be very hard. I've seen that open up a little bit in the last few years with some of the discussion about the VA and the services they need to be providing to returning combat veterans. So that's opened up, and there's a big advantage to getting your dog in that program. Number one, they analyze the situation, make sure the person needs the dog and that that is a valid service dog performing some specific task. But the financial benefit is great because if they fall under this prosthetic program through the VA will pay for medical care. Now, they don't pay individual medical care. What they've done over the years is they will pay for pet veterinary insurance that pays, and it pays directly to the vet, I think, on all their policies. So you just notify the vet that your dog is under that, provide them the information, and they can bill directly to the insurance company that is under the VA prosthetic, but they do not have to pay the premiums, the monthly premiums. The VA pays the premiums for that. Can be a big financial difference, especially for veterans that are coming back and not established in work yet. You even have veterans that are still homeless, but they may have a service animal helping them. So that's a huge financial benefit for those veterans. The work task that they're performing has to be directly related to what the handler needs, what that disability is. So looking at that and determining if it's a valid service animal is a two-step process. What's the disability? What's the symptoms of the disability that the handler needs help with? And then is that dog trained to perform tasks related to that? Emotional support animals, if it's their sole function, we've kind of already talked about this, but if the sole function is provide support or emotional comfort, they're not trained to do a task. They may not be trained at all, frankly. Most service animals get some basic good canine citizen training at the beginning of their training that includes being comfortable around people in public, knowing how to behave in a public place, responding to sit, stay commands, just general good behavior that we probably all wish our dogs had out in public. That may be part of the beginning of a service animal training. It's not even required that an emotional support animal has that. So they could be as untrained as your pet in your living room and still meet the definition of an emotional support animal for Fair Housing Act coverage. But that doesn't mean they can go out. The one exception to the Fair Housing Act that might come into play, it kind of goes back and forth. If you are in an employment situation and you need an accommodation to have your dog with you, even if that dog is an emotional support animal, not a trained service animal, potentially there is an option to file a request for a job accommodation that includes bringing an emotional support animal to work. I don't think the cases are real consistent with that yet, but accommodations for employment are individualized because Each disability might affect somebody differently. Each disability in a particular work environment may present itself in a different way. So every time somebody asks for accommodations, it's a very specific request that applies to that person, that person's disability, that person's dog, and the environment, general work environment. Who's there? What's the noise level? How many people are around? All of those things can come into play in an employment. So when you ask for an accommodation, it's very specialized. There actually is a website, the Job Accommodation Network. You can find them online by just Googling askjan.com, ASKJAN .org. You can pull them up and they will have a list, alphabetical list, where you can search by disability. So if you have a person with diabetes, you can go to diabetes and look at different kinds of accommodations that have been helpful to people. And that could include service animals. They actually even have a separate thing on their website for service animals. I don't know the last time it was updated, but they did something. So if you just want general information and you want something in your hand to look at as you're working on something, the Ask Jan website has a document you could print or download that discusses service animal accommodations generally and what that entails. The Job Accommodation Network is not just for employees, it's for employers as well. You can actually contact them and ask for assistance. So if you have an employee asking you to bring a service animal to work, you've no way to deal with it, you want to know what your options are, the employer can also contact Jan and say, look, I don't know how to do this. I'm not opposed to providing an accommodation, but I just don't have a clue how to mechanically do this. They can help you. One of their attorneys may talk to you or they'll refer you to materials that they have. So that is a situation where you might still be able, other than housing, to get an emotional support animal in a situation where the handler could take it out somewhere besides the house. Probably one of the biggest issues that I see coming up on a frequent basis is somebody in a business. I don't know why they're not training on this at the beginning in their orientations, but frequently they walk in and the first thing somebody asks for is, well, where's your certification that this is a service dog? I want to see your documentation. Sometimes they'll even ask for medical documentation, which is totally outrageous to me. They would even try. What they're asking for, though, does not exist. There is no standardized agency, federal, most states. I want to say all states, but I don't know for sure that there's no state that doesn't have some kind of certification at the state level. But even if they do, it doesn't apply to ADA because the ADA says you can't ask for certification of that. But when I say they're asking for things that don't exist, it's because there is no entity that says, bring your dog in, let's, bring your medical so we know what you need, bring your dog so we can watch it perform tasks. There's nobody to do that. In fact, generally, there's not even any requirements for a dog trainer to have a certain level. The trainers in most places do not have to have like a license to be trainers, and a lot of them are self-trained on the job training because there's not a lot of education programs for them to train. There's getting to be more, but there over the years have not been. So when somebody asks for documentation, they're really presenting an impossible situation for the individual. Now, sometimes a professional training group or a veterans training group may produce a card or a piece of paper that documents that the dog has completed their program. And if they do end of program testing, which sometimes they do, then they may document that and when they certified it or how often they check it. People carry that, but the entity still should not be asking for it. And I have a concern if people just start providing that only increases the chances that they're going to think that they're entitled to ask for that again, instead of somebody saying, you're not entitled to ask for that. The ADA doesn't allow that. And as far as I know, none of the state laws allow that either. So So what can they do? If you work for a business and you're trying to decide, how do I know if this person can bring this dog in? The ADA and the regulations connected to that allow for two things only. You can only ask two questions. And I know sometimes for some people, it doesn't feel like that's enough. I can ask these two questions and I don't know that I'm convinced this is a service animal. But you're entitled to ask if the dog, or if it's a miniature horse, a horse, is actually a service animal. If the answer to that is yes, the next question can be, what task does the animal perform? That doesn't mean, what's your disability? Tell me about your disability. It doesn't mean specific information and details about what that dog does it for because of what condition you have, but you can ask what task it performs. I generally tell clients to prepare an answer for that because anytime you go into a store with a service animal or anywhere else, that's the two things they can ask. Prepare that in advance if you have a service animal, or if you're working with a service animal handler and want to advise them, have them do that. Because if they prepare an answer for that, they can answer that second question in a way that doesn't reveal more about their disability than they feel comfortable revealing. Now, somebody who has the dog pulling the wheelchair is obvious that people know what that dog is helping to do, at least in part. They shouldn't even be asking because it's an obvious task already. But maybe somebody's not uncomfortable saying that they have diabetes, perhaps, and that the dog is that, or that they have a hearing impairment. It's not been obvious yet to somebody. They may not feel as personally vulnerable by saying some of those things, but really all they have to say is the dog is a hearing dog, helps me to hear things. That does reveal that disability, but it's not necessarily such a personal disability that they're not used to doing it. Where I see there's a problem is when you have somebody with PTSD, a severe anxiety disorder, some mental health diagnosis. Some people don't want others to know they have cancer or other diseases that are not visible, and they just don't want people to know, either because it's a personal thing to them or because they think it might affect how people see them at work or at church or in their friend group, wherever. They just don't want to say that. So prepare in advance. And I don't think you have to list every task. The dog could be trained to do 10 tasks. You don't have to have a list and tell them every task, because to be a service animal, the dog just has to be trained to do a task. So I usually tell them to know the one or two tasks that they more frequently use, that they're comfortable telling somebody, and have that ready so that when they're asked these questions, they can say it calmly. It gives them some authoritative. It makes it appear that they're not questioning or they're trying to hide a fake service animal and pretend it's something else because they're prepared to answer those questions. You cannot ask whether you're in a hospital or a grocery store, you can't ask about what's your disability. Well, you don't look disabled. I get that an amazing lot. You don't look disabled to me. You walked in here just fine. Doesn't matter. There could be a disability the dog is helping with that you cannot see. The person in the business can't ask for medical documentation. They can't ask for any certification that the dog's been trained. They can't ask who trained the dog, because you don't have to have a professional trainer. Somebody can train their own dogs, and frequently people do. There's a lot of people that were in the military that work for dogs that now use it, and they train dogs in the military. So they're training their own dogs. But anybody can train their own dog to perform the task. They also can't ask the dog to demonstrate. I'm always a little bit surprised when somebody tries that, because imagine what that is. If the dog is supposed to react and alert to a handler who has seizures, how are you going to say, demonstrate to me that your dog can do that? I'm going to have a seizure on call to do that. Be ready. It's a ridiculous request. Nobody should be doing that. And legally they can't. But from a practical, realistic, logical sense, why in the world would you ask such a thing? It's because they don't understand what it is. They expect them to show that they can walk them in if they're a guide dog and see, which somebody could see doing. The others you cannot. Professional training is not required, like I said, and that makes a lot of sense because there are not standardized qualifications for trainers. When you look at some of the most famous trainers that you see on TV that have YouTube channels, a lot of those are individually trained or they worked for another trainer and learned it as they went. There's a few. Karen Pryor has a course. Some of the universities now are starting some animal science things, and students are kind of working on some training protocols as part of their coursework. But there's not really many places where you can get a degree in animal training. There's also not many places where you can get a license in animal training. I'm not sure there's any. Your hairdresser, your barber, may have to go get a license to do that. A lab tech has to get a license to do that. They have to get a certification of some sort. That really doesn't exist for a trainer. And really, sometimes the best person to train is the person who is the handler because they have the relationship with the dog. They know how to reinforce what they're already seeing the dog react to, and they're in the best position to do that. A general category that you see a lot is, especially when somebody doesn't want to allow the service animal, is they want to charge fees. Comes up in housing a lot, but it can come up in other areas aware as well. A business can't charge a surcharge or an additional fee for providing the accommodation. In a housing situation or a hotel motel situation, they cannot charge a pet deposit for a service animal. Why? Because a service animal is a medical device, not a pet. So they're not allowed to charge a service animal. They can't charge a special fee for that. Well, if you're gonna, stay in our hotel with a service animal, then your room instead of $150 is going to be $200 because we charge extra for the service animal. Can't do that. That's illegal. It's a violation. We'll talk about how you can file complaints against those sorts of things with the Department of Justice. What they can charge for is if an animal damages an apartment, a rental house, a hotel motel room, if they would charge anybody else a fee for repairing that. So the dog has damaged the carpet, the dog chewed on the windowsill, whatever. If they would have charged anybody who didn't have a disability to make those repairs, then they can also charge the person with the animal. But that's for specific repairs. For things like, well, we've got to clean extra. We have cleaning for all our hotel rooms, but if we have a service animal in there, then we've got to do something extra. Not really sure what that would be, frankly, or how they do it differently, or if they do it differently. But they often say they do it differently. They can't charge an extra amount for that. So here's some example public accommodations. Just generally, this is by no means the end of the list, but it's ones that I see frequently. Grocery stores, restaurants, nightclubs, concerts, people to run to concerts. Sometimes they're outdoors and there's not as much of trouble, but sometimes they're indoors. And it can get rowdy and loud and people may be drinking. And so they get concerned about having an animal there. But it's a medical device. So if you wouldn't tell somebody, well, you can only come in without your wheelchair, then you shouldn't be telling them you can only come in without your service dog, because to me, those things should be treated equally as medical devices. Doctors' offices and lawyers' offices also have to provide accommodations, a variety of accommodations, and that includes bringing your service animal in. All retail shops, anything from large discount stores to an individually locally owned clothing store, is considered retail, and that's a public accommodation that's covered. Public parks, they may be under Title II, but they are also having to do that. And when you get into things like federal land parks where you have tours and those sorts of things, the dogs become an issue, but they also are supposed to, whether it's under Title II or Title III, they're supposed to make the accommodation. Schools and daycare, so kindergarten through high school, but also under kindergarten daycare, have an obligation to make accommodations, and that will include a service animal. There are some specific issues that sometimes have to be worked out, like who's going to control the animal, especially if the child is very young. But they technically are required to provide the accommodation and should be discussing that in a process. Colleges and universities are different in the way they respond, because when you're looking at schools, there's other special federal statutes that apply only through kindergarten through 12th grade schools that don't apply to colleges and universities, and it's a different process to ask for the accommodations generally. Movie theaters, hospital clinics can be that, ER rooms can be a factor, and sometimes people just don't know how to handle the service animal, but it applies to them. So if you're advising or working with any of those entities, I would suggest that you talk to them about that and make sure, number one, they know what the law is. Number two, that they're training the staff on what the law is in orientation, and that they maintain some sort of regular reminding training once a year, once every 2 years, however long it is, to make sure that they stay up with what their obligations are under service animal law. Because if there's a complaint that goes to the Department of Justice, or if they sue, a lot of times, your high school student that's working at a fast food place is not the person they're going after to pay damages because they don't have any money. Who are they going after? They're going after the entity, especially if it's a national chain fast food place with money to pay for that. They're going to get sued because their agent and their employee denied the person a service animal. And the more difficult that person is, the more rude, the more hostile, the more disrespectful that person is, the more likely you're going to get a large verdict against you. Vests become a big deal. It seems like everybody ought to put their dog in a vest. It used to be with guide dogs, they were in a vest that had a harness on it that people held on to. People got used to seeing that. So a lot of times a service animal handler will go in and they will say, well, where's your vest? You don't have a vest. How do I know it's a dog? If they have a vest, you don't know it's a service dog because they can order that vest off Amazon, off any kind of, they can go into different stores and get a vest and add patches to it. The vest itself does not mean anything. A lot of handlers prefer to use a vest. A lot of the veterans that I've worked with not only use a vest, but they have it specifically identified. And for me personally, representing them, that really ups the ante in whether I'm willing to file a lawsuit. If they have given them notice that they are not only a service animal, but it says U.S. Army on theirs or U.S. Air Force and has an American flag on it, and it's clear that that's a disabled veteran with a service animal, and they kick them out. At first, personally, I think that's going to upset a jury greatly. Most juries, that's just going to bother them. So you're increasing that, but it's not required. So why wouldn't somebody want to wear a vest? I'm going to give you my best example. A disabled veteran that I knew, a woman who had fairly young children, who went out in public with her. And she was concerned if she might have a harness on her dog or a vest on the dog, but not labeled as service animal. Why? Because she felt that potentially made her a target, that somebody might see that and think she could not defend herself or could not defend her children. And so in order to do that, she would not put a vest that identified it as service animal. Now, the handler does have to have the dog on a leash or somehow tethered to that person, unless having the leash prevents them from doing their task. But they do not have to have a vest. And insisting they do is kind of ridiculous because the vest doesn't really mean anything, except for some people, it helps them explain early on, point to the vest and say, no, it's a service animal. The animal, no matter what, even if it is a trained service animal, has to be under the control of the handler. That can mean different things in different sort of settings. What constitutes control? I don't really see that very often with trained service animals. So if the dog is out of control, if the dog's snapping at somebody, that's a sign to you it's not really a service animal, in my opinion. If the dog is rushing up, they see another dog and they're trying to, check that dog out, that may be a sign that it's not a service animal, unless they tell you it's a service animal in training. And that can happen sometimes early on. But if a trained service animal who's already been trained to go for public access related issues, I very seldom see that. I once was in a very, very small room where I had tried to space out when individuals with service animals would be coming in. But at one point, somebody came in early and somebody left late. And I ended up having one handler with a pit bull and one handler with a huge Rottweiler passing in a space that was about 3.5 feet wide between the chairs. And I just frankly stood back and watched to see. Those dogs walked by. The dog that was moving looked at the one that was sitting down on the floor, turned to the door, and just walked out. Neither dog reacted. That's what I expect with a trained service animal. You're not going to have that because that's what they're trained to do. The problem that you run into sometimes is somebody tries to bring an ESA, an emotional support animal, or their pet in. The pet doesn't behave that way. So there's been a lot of problems with pets that people claim are service animals that are not trained, engaging in that behavior, even attacking that behavior, which has led to some changes in laws in some places because there have been situations where a guide dog or some other highly trained dog that maybe was trained by a company that breeds their own dogs for certain characteristics, those dogs can cost $50,000 and can be destroyed. Their training can be destroyed in 10 minutes by somebody bringing their pet who then attacks the service animal. Because once that happens, the service animal may never be able to behave or work in the same way in a public environment. And they have to be retired and start over to get another $50,000 dog. So encourage people that you know not to take their pets out and pretend that they're service animals. They're not the same thing, and they're hindering the rights of people who really, really need those dogs out there. Now, if the dog cannot be tethered for some reason, because of the disability or the task it performs, then they have to be able to be under the voice control of the person. There have to be signals, hand signals that they respond to, or voice signals. There could be some other unique training things that they do, but the control is the factor that the dog has to be under control. Can the dog ever be asked, can you ask if you're the business entity to have a dog removed? Yes. Be careful about doing that. Make sure you're doing it only when it's necessary. But there are situations, and some of those situations, frankly, to me, are the ones that may indicate to you the dog's not really a service animal. Or it could be that the dog is sick that day, maybe acting in a way that is inconsistent with its training. I don't see that very much, but if the dog's out of control, the handler doesn't have control over it, and they don't take a step to get control. So if the dog does something, if they don't pull them back in really quick, they don't give them a hand signal, they don't with voice control, whatever is necessary to get that dog under control, the very fact that they're out of control is a reason for asking them to be removed. If the dog's not housebroken, it's a reason to ask for them to be removed. I really don't see that come up very often with an actual service animal. I have seen that a couple of times happen with a service animal that was in training and they were starting to do the public access training, and the dog might have an accident because they're still working with it. But at that point, you can ask for the dog to be removed. If the dog's aggressive, clearly, if they're biting, they're growling, they're snapping at people, they're trying to get to other animals or individuals, that to me is a huge sign that the dog is not a service animal, number one, but just that behavior allows the business to say, no, I can't allow you to stay in. And even if the dog's just not clean, it's not been bathed, it's not taken care of, it smells really bad, that can be grounds for doing it. Again, I really see that with a service animal, unless something has just happened and the service animals had to run through the mud to get somebody's attention. You really don't see that because people with service animals tend to recognize they need to take care of that. And they may have a dog that's got a lot of expensive training and they're taking very good care of it medically and just hygienically to make sure that it can go in public places. What should your staff do if there's issues with it? Number one, don't exclude them unless it's a serious reason. Don't even ask them to remove it if it's not a serious reason, if you think it's a valid service animal. And you have to give the handler the option to stay. So if the dog is brought into a restaurant and you think it's engaging in any of those behaviors, the business can say, you need to remove the dog. You're free to come back in and we'll serve you when the dog is not here. If you don't want to do that, we'll be glad to make your meal to go so that you can take it and bring it to you in your car, but you need to get the dog who's behaving inappropriately out of here. That's a two-step process. So you can ask them to leave, but you can't deny them the services at the same time. You have to provide them the opportunity to get the goods or the services they came for without the animal being present. That's only after the dog has exhibited these other behaviors. You can't just say, hey, we have a no dog policy, but we'll serve you. That's not the same thing as your dog's misbehaving or is aggressive in here. We can't have the dog in, but we will still serve you. Allergies and fears are another common one, and it's a common misperception that, well, if I'm allergic to dogs, you can't bring it in. That's really not what the ADA says, nor is it what the cases have said over the years. We'll talk about some specific ones when we get to cases, but just generally, if someone else in the area has an allergy to dogs or they're afraid of dogs, maybe they were bit by a dog when they were 4 and they've never really gotten to where they could trust dogs again, that's not grounds to say to the service animal handler, you can't bring your dog in. If they have an allergy, that could be classified as a disability. So you have 2 people with a disability that have irreconcilable needs for accommodation. The ADA says you have to accommodate both. So in most of those things, say you're at an employment situation and one of your employees has an allergy, the other person needs a service dog. But the person who has an allergy with a service dog sits in the next cubicle over. So maybe the solution is you move them to different ends of the room, or you put them in different rooms, or they come in different entrances and leave by different exits. There are things that you can do that are other accommodations, but the business or the employer is obligated to look at both of those, the needs of both of those, and engage in a process to figure out how do we allow both people to come here and have the accommodations they need. It can be separation, but it could be other things that occur. There could still be a direct threat issue. We'll talk more about what direct threat entails. But if the dog poses a direct threat to somebody that cannot be alleviated, then you have a different situation and some different issues that you're going to have to engage in. The Reeves Immediate Medical Center case, actually it involves also a business called Grifols, Grifols, that purchased or took over Immediate Medical Center. And Reeves had gone in to the medical center to see a doctor. Well, actually, Grifols may be a different case than this particular one. This doctor was not somebody she had seen before. She went in with her friend or her partner to the doctor's appointment, had the service dog with her. And she was looking for a new primary care physician. So she had not been here before to do that. She was scheduled with a particular doctor. When she went in with the service animal, after some discussion, the front desk people told her, okay, we're going to have to make some changes because the doctor you're scheduled with has a severe allergy to dogs. So she's still willing to see you, but your dog will need to stay out here in the lobby with your friend. I think they even proposed the dog could come in and stay outside the exam room nearby, but outside the exam room, but could not go into the exam room with the doctor in there. This dog handler got very upset. There were some videos posted at one point, I don't know if they still are, where it's like, just like, it's 2026, everybody's got to pull out their phone and start filming everything. And was very angry about it, demanding the rights. I have a right to be here. You can't deny me the right to be here. And the doctor's office kept trying to say, but we can't with this doctor. So if you want to see somebody today, we'll try to fit you in with another doctor. I mean, a different day. We'll try to sit you in with another doctor on a different day. If you want to see her today, then the dog's going to have to stay out of the room where she's at because she can't have that. And that's a discussion that had come up before in an allergist office, in doctor's offices, but especially where it's an allergy doctor where a lot of people in the room have allergies. And there really wasn't a clear answer to any of that. But in this case, the court looked at that and said, no, in this particular situation, with this particular doctor and her particular disability and reaction to dogs, for her, this was a direct threat to her health. So you were not entitled to visit with her with your service dog there. And since they had provided other options to provide her services, she didn't win that case, which actually makes sense to me under the situation because it wasn't just, hey, we have a no dog policy, get out of here. This doctor actually engaged 2 or 3 times during this day to try to come up with other solutions to have her seen, but not with the dog in the room with that particular doctor. So I don't know that that's a bad decision, and it does give some guidance when you're trying to decide where do you draw the line when somebody has an allergy. And it cannot be accommodated by separating the people, because when you're trying to see a doctor for an exam, there is no way to separate to try to accommodate both people. So in this decision, that probably is a pretty good clear line. Bennett versus Hurley Medical Center is another one that involves a medical center. It also involves a student, a nursing student who was now doing clinicals at a hospital. And to Hurley's credit, they actually did try to take several steps to allow the dog. They initially approved her to bring her service animal with her for clinicals. They tried to work out special rules for it. How was it going to work out? There were certain floors where the clinicals were done for nursing students. I think there were two different floors. And they brought the dog in. But when the first day, I think, when they brought the dog in, a coworker had an allergic reaction to the dog, number one. So that raises certain issues about how can you separate them out. But the other one that I thought was really unique was that somebody came up and said, is there a dog on this floor? Because the patient they were visiting was allergic to dogs. Patient was down the hall. And they asked why. It's like, because he or she is starting to have a reaction that they have around dogs, but they had not even seen the dog at that point. And so now you had a coworker and a patient with a reaction to that dog. Hurley Medical still tried to look at, is there a way to accommodate? Their defenses can be that it is an undue burden or a fundamental alteration of what they do. That's for any ADA accommodation. And they tried to find ways to accommodate without even raising those defenses at first. But eventually that didn't pan out, because on the 2 floors where the clinics would occur, there was no way to guarantee. There was people on every floor that might have been affected. There was no way to move those people, because to do that would have taken moving multiple patients and reassigning staff people into areas they weren't normally assigned to work. It was going to be a pretty big project to move everyone else for her to come to the 2 floors with her service animal. And so that is another case where they found it was a direct threat, because there actually were 2 allergic reactions, not even just the threat of an allergic reaction. There were some, both by coworkers and patients that were in the hospital, and there didn't seem to be a reasonable way to move and separate everyone and still allow her to do the clinicals with her dog with her. Service dogs in training are an issue because the ADA historically has not addressed that. It doesn't specifically say service animals and trainings are allowed in public the way service animals are or when they are, even though from a practical standpoint, to complete training, dogs generally have to be trained in public places at times. So you may have some businesses that allow that. Things like Lowe's Home Improvement, Home Depot allow people in, Tractor Supply allows people to bring their dogs in. Other businesses may do that. Some may, if you request it at certain times, but just generally, you can't demand the rights of a service animal in the same way if the dog is actually in training. I once had somebody who trained his own dogs, had trained several dogs, and trying to be as straightforward as possible about it, he put on the dog's vest, service animal in training. When he went into a hospital to visit a friend, somebody saw that and said, you're not allowed to bring a dog in training in here. ADA doesn't allow for that. So they knew what it was, what the law was, sort of. What they didn't realize is that Texas, in the state law, allows service animals in training. So even though here they were not allowed, they weren't required under ADA to allow the dog in, they were required under state law. So if you have a service animal in training issue, I urge you to look at your state law to see if your particular provision where you're at also allows for service animals in training, because that can open up a door. The other thing is it's not really clear what an in-training dog is, because there's no rules specifically about what's a sufficient amount of training once training complete. And I don't know that I've ever worked with any service animal that wasn't still training. They weren't considered in training by the handler because they had learned at least one task, maybe multiple tasks. But in my experience, the dogs still continue training because they're reinforcing those tasks. They may be adding tasks as they go, but they do perform a task. So that puts them in the definition of service animal. It may be safer if you're in that position with, and you're the dog handler, to make sure when you start taking them into any public place that isn't known to allow dogs, just generally, that you have the dog trained to complete at least one task, so that when they ask you what task does the dog perform, you can tell them that there is a task they perform or how they do it. This is just an example in the Texas statute of what it says. That's not really even a very clear example. I'm hoping your statute's a little bit better, because this was language from the original statute that has been reworded and modified over times, but it refers in this section to an approved trainer. There's really no definition for what an approved trainer is, so it's not really clear. Your statutes could have similar issues in them if they were developed right when the ADA first came into effect and haven't been modified yet. So missions dogs, working dogs, is an interesting case that sort of just turns on its head what I just told you, because ADA still doesn't refer to service animals in trainings. But this was a very unique situation where a training group, the woman who ran the group, I think, had her own service animal that was trained to help her. I think another person or two in the group was a handler, had their own, but the rest of the people were volunteers for this training organization that helped train dogs for other people. That normally wouldn't be considered somebody that's covered under the ADA, maybe under our state law and maybe under other state laws, because a lot of them may say you can allow service animal in training as long as the trainer is with them. But in this case, they came in as a group training into a mall. The Maine Human Rights Act had provisions for service animal in training, number one, which may have played some portion in this, but the wording of the case doesn't really specifically say that's the reason they decided this. A lot of things went on and there's a lot of issues in this case separate from the ADA issue: false imprisonment, 1983 action, civil rights action against a law enforcement officer that showed up. Different things can come up in these cases where multiple service animals are involved. But there was initially a problem. One of the women had been in about 6 months earlier. She and a friend had their service animals. They were at the food court eating. One of the security people had contacted them, said no dogs allowed, and they said they're service animals. And he was like, no, there's no pets allowed. You need to get out of here. But then he left and he didn't make them leave. No change for that until 6 months later when they show up with this whole training group. Oddly, this mall did allow service animals in training. They did allow them to come in, but it had asked that this large group like that they notify them, because they came in like on a busy Saturday and they thought it was creating a problem. So they were still talking about that with them and asking them to schedule a time. But generally, if you have a service animal, you don't have to schedule a time. You don't need to call the store and say, hey, I need to know what time I can come in with my service animal, because the service animal is not supposed to result in you being treated differently than anyone else. If I don't have to make a call for an appointment and I don't have a service animal, then the service animal handler also should not make a call. So there's a lot of discussion about that. Then the handlers were threatened with arrest, and at some point the security people told them they couldn't leave. one woman wanted to walk outside. They let her walk outside, but the security guard says, and you better come back or something like that, which of course led to other claims not under ADA for false imprisonment. Um, they also threatened to criminal trespass them. If you're not familiar with what that is, in any state, there may be a law that says a business owner can tell you you're no longer allowed on their property. They can ask the police officer to issue a criminal trespass warning, which means that if you come back on the property, then they check their records. They already told you couldn't come back. Then they arrest you for trespass. So they were threatening to do that while they were engaging in this process. So here's what the court looked at. They did find that there was potentially future harm because they planned on coming back. They had come back before and they were going to come back more often. They looked at the organizational standing, since the biggest portion of these people were not service dog handlers. Can the organization do it? That's more than we could cover in this, because you get into your standing to pursue a claim. Standing means, do you have an actual issue affecting you that allows you to go to the court and say you need it redressed in some way? And there's different kinds of standing. So the organization was attacked basically by the mall, saying that, well, it doesn't apply to them. They don't have any rights to sue us because they're an organization. Court found they did have standing in this circumstance. Might not another court. Not all courts might have found that, but in this case, the court found they did have standing to pursue it, in part because of their connection to people with disability, some sort of a social standing connection to them, because they were training for people with disabilities and they were there with people with disabilities. And then they found multiple fact issues that were limiting the ability to, the initial thing here was requesting a summary judgment to get a decision in the favor of the mall without going to trial. And the court found a lot of different reasons, said, no, that's a genuine issue of fact that has to be tried. That's the genuine issue of fact that has to be tried. They found several of those and said, you're not entitled to summary judgment. You're going to have to try this with a court. Restaurants are frequent places where the dogs have problems. So the business that sells or prepares food, they still have to generally allow service dog in any area where the public's allowed. So maybe not their kitchen or wherever, but the bathroom at the restaurant itself, and the whole restaurant where the public is allowed access. Over the years, there's been several cases where a restaurant has a patio, and they're like, we don't allow dogs in here, but you can go out on the patio. And they think they've accommodated because they've done that. That's not acceptable. You can't be forced to eat out on a patio just because you have a dog, a service dog. Now, if they allow pets, they generally allow dogs, but only allow dogs on the patio. That's different. They're not service animals. But the service animals are entitled to go in anywhere in the restaurant that the handler or members of the public could go, and into the restrooms to do that. For a while, people were arguing about, well, the health law is this and the health law is that. That doesn't override this. You may have a state health law that does that. Sometimes your state equivalent to the ADA may particularly say the health law doesn't override this. But some states have even put language in their health laws to say except for, so that people who are training on health laws, who are getting those health law certificate completions, are aware that the service animals are allowed, and that you can't isolate them to a particular area of the restaurant, whether it's the patio or a particular area. I have seen some where they say, well, you can't sit near the bar. You've got to sit over here at this table, or you can't sit at these tables on the left side of the room. We put all the service dogs on the right side of the room in the far corner away from the kitchen. Can't do that either. Not if anybody else could sit in either place. Chris versus Columbus is a very unusual case to me that deals with service animal, and it'll sort of give you a broader idea of things that can come up besides the normal kind of situations that arise. Miss Chris was a very frequent patron of this restaurant. In fact, she got to where she was coming in there every day And she would come in early in the morning, like 8 or 9 in the morning for breakfast, but she didn't leave. She would stay through lunch. And she talked to employees. In fact, eventually there was one of the employees that she became friendly with. When he took his lunch break, he would come sit and have his lunch at her table. And she was allowed to stay there all that time, eating her 2 meals a day. But in between, she was hanging out. It became her social environment for her. At the time when that started, she didn't have a service dog. And then she got a service dog. And then issues sort of started rising. Those issues did not entail, however, that they told her she couldn't come in anymore. They also didn't entail that they wouldn't serve her food anymore. What happened and what she complained about is people became less friendly. They did not greet her the same way. Nobody came by just to chat with her while she was sitting there eating or hanging out in the facility. The guy who had been having lunch with her stopped having lunch with her when the service dog was there. And she felt she was now being treated differently and discriminated against because the service animal was there. But the court did not agree with her about that because they hadn't denied her actually any services. And basically, there's a line in the opinion that says the court says Title III of the ADA does not include a civility code requirement, something of that. You can't make them be civil. Now, at some point, I think that behavior could get bad enough that it's discriminatory. It's designed to force them to leave the premises. That really wasn't what the court found in her case. They found that they went from being very friendly to not so friendly, but also, and maybe even yelling at her at times, maybe even something that you might consider rude, but they were not discriminating against her in the way that denied her services because of the service dog. This is a very, very old case. Johnson versus Gambrinus is one of the early service animal cases that I saw go up this high. It's to an appellate court in the Fifth Circuit. This is out of Austin, Texas. There was a brewery in Austin that had tours of their facility where they made the beer and different things. And they had a no pets policy, no animal policy, and they would not make an exception or modify their policy for Mr. Johnson to bring his service animal there. So even back in the early days of the ADA, when that got tried, the court found that they can't have a blanket policy about that. Even though they were making something in this brewery and the tours were going through, they were allowing other people to come through all of that area. That makes me question the contamination issue by itself to some degree, because it's not a sterile environment if they're letting people off the street walk through in their street clothes and they're not having to wash their hands and they can wear their shoes. They came in, they're not covered. That would raise those kinds of concerns for me. But in this case, what the court looked at is there's a lot of parts of that tour. And maybe one part of that was where they had the best claim of a potential contamination. And the court said then they should have modified their policy to allow this person with his guide dog to go through the rest of the tour with his friend that was with him. And they could maybe carve out something for that particular contamination area if they could show there was really a contamination risk. So that was one of the earlier ones that said restaurants, places where they make food or drinks, really have to accommodate a service animal. They can't just claim, oh, well, it could contaminate food, it could contaminate a drink. We can't have them in here. I want to discuss a little bit about the police, not a lot in detail, and these cases are not as specific on the issue, but just generally, there's been concerns on some of the cases I've come up with about the way the police handled the case when they came. The police should know what the ADA is, and sometimes you will have police officers respond when there's a situation, and they'll tell the business owner, you're violating the ADA, they could sue you, but the ADA is a civil statute. Now, you may have a state statute, again, that has a criminal penalty in it. That's a little bit different situation to me and how the officer should respond. But just generally coming in, there's been claims, well, not only did the business discriminate against me, but the police discriminated against me because they didn't force the business to let me come in with my service dog. So there's the next couple of cases that we're going to talk about kind of had that situation, but you usually get a mixture of things. So you may have, mostly it's Title III cases, public accommodation businesses. It could potentially be a government office under Title II. But one of those statutes is generally going to be involved in the claim. And then when the police get involved, they may try to include the police in the ADA claim, saying that they discriminated against them under ADA as well by whatever actions they took or didn't take. They almost may also add a section under Section 1983, which is a civil rights statute, that if there is a violation of constitutional protections by a police officer, then that claim could fall under this statute. So when you get police involved in a service animal case, you may get a mixture of statutes that are being raised other than just the ADA, even though they're related to the claim of the ADA issue. This Albright case out of Louisiana was also kind of an unusual fact situation. This restaurant was where this event was being held was actually a setting where they were having a neighborhood watch group meeting, and two of the administrators at the local sheriff's office were the guest speakers, and they were there talking about neighborhood watch programs and how to protect your community and that sort of thing. Mr. Albright had a condition that required him to have the dog with him all the time. In fact, I believe he had narcolepsy, and the dog helped keep him awake, keep him alert. He wanted to bring the dog into this meeting that involved the sheriff's office. The owner didn't consult with those two speakers, but he told them, no dogs, we don't allow dogs here, you've got to leave, you can't bring the dog in here. Eventually, law enforcement was called, and the responding department turned out to be the same sheriff's office as the two speakers. Different officers came in as the responding police officers. So when they got there, they were also trying to find out what was going on, figure out what they could do. But the manager or the owner kept insisting that they couldn't bring the dog in. So Albright sued, went after both the cafe owner, the manager that was there, and the police, claiming that they had denied that. The court found a genuine issue whether the police aided in the denial of the disability, but you get into problems about establishing 1983 claims if they're violating a constitutional claim, and that can come up in a different situation. So Cordovas sort of brings that situation a little bit more forward. Some of the defendants were Title III defendants because it was a mall, a privately owned mall. But there was also a 1983 claim included against the police officer. Cordovas had a dog that was trained to provide a task, but that dog was, I think, a small white dog that was in a stroller. She kept it in a stroller, and she said the dog was close enough in the stroller to alert. It was like a small white poodle, I think, in a stroller. So that's a situation where you're likely to have somebody in the business start asking questions. Most people don't initially think of a dog in a stroller as being a service animal. Not that it couldn't be, or a dog that's strapped to you like in a baby carrier also could be. In fact, somebody handling a diabetes dog that's small may strap the dog to it so they're even closer to tell if the glucose levels are going up or down. But in this case, the mall security had a question about it. So there was first interaction with a security guard. Then an off-duty officer was called who was there, and he ended up arresting Cordovas based on what the security guard said about her. It really got into a huge, extreme situation with people and claims of use of force and other things that probably everybody could have probably handled a little bit better. So in the end, the court denied the summary judgment. The defendants, the mall and the security company, had asked for summary judgment, and the court found no, there was enough factual issues about whether they had discriminated under ADA, that the plaintiff was entitled to take that to trial. They have to determine that there's a genuine issue of material fact. If the judge finds everybody agrees on the facts, or he knows what the facts are, and legally those facts don't support an ADA claim, then they can grant the summary judgment. In this case, he didn't find that. But the issue that came up with 1983 is they'd gone after this officer individually. He was in the performance of his duties, and the court found that his qualified immunity protections as a police officer performing his duties locked in, and that the plaintiff, in how she pled this, was not able to overcome that. So I don't have a clear, I've looked at this before to try to see if there's a way to do that, especially in my state where there is a criminal penalty. And really, I think all the officers should be, if they walk in and somebody says, no, you just can't bring a service animal in here, to me, they ought to be getting out their citation book immediately and writing a ticket to that person. That doesn't happen very often, even though the statute's been around. I've seen it a few times, a few officers do it. Most of the time when I've seen an officer write that citation, it was either because he was former military and was very familiar with it, or knew something else about it from a prior case and had it come up and approached a prosecutor and asked them to file a case, even if he didn't write a citation. So let's talk about service animals and transportation. There is a photo here. So this photo is a large peacock that's sitting on a handle of a luggage cart in an airport at the area where you would pick up your luggage. This is Dexter, actually. Dexter's no longer with us. He's passed on. But he was brought to the airport by his handler, claiming that he was an emotional support animal. At that time, emotional support animals, as in housing situations under the Fair Housing Act, were allowed to travel on airlines. Emotional support animals do not have to be dogs. So you could have, there's some things they could restrict, like you can come in even before and say, I have an emotional support rat, I have an emotional support boa constrictor that I want to take on. The airlines had some control over limiting that even before. But generally, other animals that were emotional support animals, once somebody documented that to the airline in some way, they were allowed to fly with them. And that could be a dog, it could be a bird, it could be a rabbit, it could be a lot of different animals that people used that they said provided emotional support to them. As you can imagine, that became a huge target for scammers to do, because service animals, emotional support animals, could not be charged additional fees to fly, and they could fly in the cabin. So you found a lot of people who just wanted to fly with their pets, and they would say, oh no, that's my emotional support animal. That's part of the reason there was a problem. And there was issues with it over the years, trying to straighten that out as it came up. It looked like that was going to create an over problem. There wasn't some way to get control of it, with all these people that were not actually bringing true ESAs or service animals on, because it created problems in the flight as well. Those dogs were not trained, or those pets were not trained necessarily to fly for several hours without other complications coming up. The top of the line, though, was when Dexter came to the airport, because they had already told her he couldn't fly, and she brought him like this. He was not in any kind of crate. He was not restrained. You can see how big he is in this picture. Imagine if he's opened the span of wings, how much room he takes up on a plane. So they kept telling her she could not take this emotional support animal. And it became quite a process. So that was in 2018, I believe. In 2019, they started working on new policies. The Department of Transportation started saying, okay, now things have gone too far. We're going to have to figure out how to handle this. I don't know that they would have done that potentially ever, but certainly not as soon as they did, if it hadn't been for Dexter and the incident and the disturbance he created at the airport. So their final rule on that came out in 2020, where they put in their own definition, and basically service animals can fly still, and there's policies for doing that. Emotional support animals cannot fly. You can obviously still fly with your pet if you want to pay the extra amount and they fly in the cargo hold. You could potentially do that with an ESA as well, but you can't bring them into the cabin and travel with them on the airplane itself. It is not a service animal. It's not considered a service animal, so it doesn't fall under that. And there is no longer an exception for emotional support animals like there was before 2020. So now the DOT defines, they have their own definition for a service animal that's a little bit different, close to, but a little bit different than the ADA wording that came out in 2011 from the Department of Justice. Most entities and states, if they were going to change, tried to modify to get closer to or to be exactly like the DOJ's definition from 2011. This one, DOT has a little bit broader. So their definition is a dog, regardless of breed or type, that is individually trained to do work or perform tasks for the benefit of a qualified individual with a disability, including a physical, sensory, psychiatric, intellectual, or other mental health disability. Now, a qualified person with a disability, by definition under the ADA, is an individual who has a mental or physical condition that substantially limits one or more major life activities. So you could have a medical condition that even a doctor might consider disabling to you in some way, and it still not meet the definition under the ADA because it has to substantially limit one or more major life activities. But under the DOT, if you have a trained service animal, trained to perform a task or do work, and the person is individually qualified under the ADA, then they're allowed to bring the service animal. As you can tell, that lets out the ESA because they're not. Now, if you have a dog you've used as an emotional support animal and you take it and you get it trained to perform some alerting task, then maybe that dog has become a service animal. But until that dog's trained to perform a task, it is not. There's a couple of pieces of paperwork that I wanted to mention. You can go to the Department of Transportation website and pull these off if you want to see what they look like before you're traveling with a service animal or before you're advising somebody who wants to travel with a service animal, because the airlines can require this. There's actually names for them. Let me give you the actual name. U.S. Department of Transportation Service Animal Air Transportation Form is the first one. So it includes things like the vaccination for the dog, task that it performs. There's a list of things that you have to complete, and they are allowed to ask that. It's different than if you go into a restaurant or a grocery store where they're only allowed to ask 2 questions. Here, it's a different situation, like it would be if you're asking for college accommodations, if you're asking for accommodations at work. In those situations, the entity can ask for a little bit more information and documentation because you're going to be there longer term. So the airline can require that before they go on. For flights over 8 hours, there's another form they may ask you to complete if you're the service animal handler. The official title is U.S. Department of Transportation Service Animal Relief Attestation Form. And basically that's saying that you are attesting to the fact that this dog can travel over 8 hours, and it's either trained not to relieve itself for that 8 hours. It will go for 8 hours without having to relieve itself, or it can relieve itself without creating some sort of health problem. In some airports, you may find a dog relief area, maybe over near restrooms and things. They may have a place indoors for you to take your dogs without having to take them out of the airport. You're not going to have that on the plane. So one of the examples they give of a dog being able to relieve itself over that amount of time without creating a health hazard is that the dog is wearing some sort of diaper, disposable diaper that you could do. There could be other ways, but that's one of the ones that they mention in the form. So those can be required. It's not illegal to require them, and you are almost certainly going to have to complete those in those situations. This transportation case does not involve an airline. It involves a county transit. So it's a Title II because it's run by the county, Title II transit organization. It's a little bit different in nature because the guy, Mr. Goodwin, sort of worked with him for a while. And it's a situation where they weren't denying him the ability to come on, but he would take his service animal on a bus and repetitively, The drivers, no matter which driver, different drivers, different buses, would say, I need your certification that that's a service animal, or your documentation that that's a service animal. I don't have documentation, and I'm not supposed to give you documentation. ADA doesn't require me to give you documentation. Ironically, in those situations, the bus driver still let him stay on the bus and ride each time. But because it kept happening, it became a problem. I mean, each time you're getting asked that and you have to explain that, it's sort of asking somebody for their papers, give me your papers proving you have a right to be here. And that becomes a problem. It can become embarrassing, delay things, and makes other people upset with them. So at some point, this guy was tired of being asked. He said it happened to him about 30% of the times that he rode. That was his estimate. But he, on 4 specific occasions, went to the transit and filed a complaint. So they had notice 4 times, and they kept not doing anything about it, even though it had notice. None of the drivers asked the 2 questions they could ask. They just said, I need your documentation. You would have had even a much worse case if they said, well, if you can't produce the documentation, we're not letting you on the bus. You can't come on the bus. And he missed things, because that, to me, if you have a state law that provides for damages, it's going to open up more cost for damages. But they wouldn't even ask those. They just wanted the certification. In fact, one of the drivers, when he said he wanted it, he said, there is no certification. They don't require certification. And his response was, well, then how am I supposed to know it's really a service animal? I'm supposed to know he's a service animal based on what they tell you when you ask the questions. And that's the limit of your ability to inquire. And that was not happening. So his concern was just the act of asking for the documentation, because it's a violation, or is not allowed, was a violation of Title II of the ADA. Service animals in hotels and motels is frequent. And a lot of times the business owners don't understand the law. They may not have any real familiarity with ADA, or the staff that is working there may not have been trained on the ADA. So there's some general rules. They can't charge a pet deposit, an additional fee. They can't charge additional rent. So if the hotel room was a $75 room and they wanted to charge you $125 for it because your dog's with you, that's a violation of the ADA. They can't charge an additional amount, say, well, we're still going to charge you $75 for the room, but when you check out, we're going to charge you an extra $50. Whether you've been here 1 day or 5 days, we're going to charge you $50 because we're going to have to do extra cleaning on that room. Not allowed. That's a violation. Like with renting apartments and homes, though, if there is if they charge anybody who has a dog that damages the property, they may have a pet-friendly environment and other dogs are allowed. But if they damage the carpet, if they damage the walls, if they damage the coverings on the furniture, then if they would charge those people, they can also charge the dog handler. Spectre Investments was sort of an unusual situation in that he was traveling. That can sometimes raise a standing issue that has to be addressed, because you have to intend to go back to the place to have standing to contest it. But he had gone, he was trying to stay in a hotel. They said they had 1 room available. The whole facility had about 15 or 16 rooms, but 1 room was separate. It was a separate building. It had a separate entrance. It had some special view. And when he got there, they said, that's the only room that's available, and we don't allow dogs in that because we never put dogs in there so that it's available for somebody who has an allergy issue. Actually, I've actually had this come up in a case, surprisingly. You'd think the cabin thing was an unusual thing, but I have had a situation before where a business would allow them in one particular room, but in other rooms, they would not allow them to take the dog, partly because of the furniture that was in there and how it had been upgraded and the stuff. They wouldn't allow it. Again, that's a violation to do that. In this case, it's even worse because there was no other room available in town. The guy tried to find another room, but there was a festival starting the next day, so he had to go to another town to get a room. The defendant filed a motion to dismiss, claiming he wasn't really discriminating. It was, I think he claimed an undue burden for this room because they held it open for somebody with an allergy. And they denied their motion to dismiss. I personally question whether they were really holding that room open for somebody with an allergy. That doesn't make sense to me that they would do that. And again, that person's not there. Even if they were saying that person with an allergy disability, we're keeping it for them, they're not there. So they need to modify that policy to allow somebody else to stay in the room. And if they have to do special cleaning, they have to do special cleaning. Schools K through 12, you can have service dogs there as part of the plan. If you have not ever worked with a special education program or a 504 program in a school, it has specialized rules and procedures that it uses. There is a statute called the Individuals with Disabilities Education Act that applies to that range of schools, not colleges, but to this age group of schools. And they have their own special rules about how they get accommodations to them. So there's usually a team. Depends on what state you're in, what that's called. Most states call that an IEP meeting, an individualized education plan meeting. Texas calls that an ARD meeting, admission review and dismissal meeting, but it's the same thing. They're looking at the needs, the disability of this student, what does he need or she need at school to perform well, and a service animal can be part of that. There can be issues raised. Is the child able to control that service animal on their own? So there may be things that have to be reviewed before that happens. But there's been a conflict for a while about, well, if they deny you a service animal, are you really asking for something related to education? So you have to follow all these rules under IDEA. You have to do that, which is, there's a long exhaustive procedure under that is required to, if you have an IDEA issue, before the parents could file suit against the school district. The Fry versus Napoleon looked at that and and this is really the first time that I've seen this. I'm not aware that it's come out before, that IDEA has to be followed if the underlying issue is, did the child not get a free and appropriate public education? But if it's something not related to FAPE, then they don't have to exhaust all of those IDEA remedies before they can file suit against the school district. And in this case, one of the issue underlying that was a service animal. The CG case was a student who her service dog, George, worked with her, performed tasks related to a variety of disability issues. The school kept trying to take the position it wasn't a true service animal. That's what they call it, when a true service animal. That's, if it's clear it's not a service animal, that's one thing. But defining a true service animal, when the student, the parents, and the medical providers have already looked at this situation, is really branching out and putting yourself on a limb if you are with the school district, in my opinion, and just asking to get sued about it. But the student was asking for a preliminary injunction while the case was pending, in this part of the case, while the case was pending. The district fought that. They're like, you can't do an injunction, because the injunction was to allow the student to bring the dog with her to school while the litigation was going on. And they were saying, no, no, no. So there's some legal issues. You don't really probably want to get into the muck of that right now, but the court looked at, is it a mandatory injunction or is it a prohibitory injunction? They're two different things, and they have different standards that apply, different analysis that you have to look at to do that. The mandatory one really has some higher level things that might have occurred. And the court in her case she's actually looking at a prohibitory injunction request to bring the dog with her, and they granted the preliminary injunction. So even if that full litigation, either to trial or to settlement, it could take 6 months, a year, 2 years, that preliminary injunction would have allowed her to bring the dog in during that time. So the school was still going to have to figure out how to make the accommodation work. Colleges and universities, three statutes generally is what you're looking at if you've got that coming into play. Title II, state schools. So if it's a state college, then it's covered under Title II, but their responsibilities are still very similar to a private school under Title III and what they have to do. There can be an additional one for both of those, and that's Section 504 of the Rehab Act, which we talked about was a precursor to ADA and applied to federal agencies and entities that got federal funds. The reason it applies even to a private school, I mean, clearly you think of tax money, federal tax money funneling down into a state university because of just how the budgets work. But there were some questions, well, it doesn't really apply to private schools because they're not getting that tax money. And over the years, the court was like, that's not really true because both state college students and private college students apply for federal financial aid. And if your private college or university accepts federal financial aid, then you are a recipient of federal funding and you're covered by 504, which may open up some other issues and also potentially open up the Department of Justice looking at you if you're violating 504 while you're taking federal funds in some way. This 19 case is fairly new. It's just in the last few years. It's also a complicated fact situation a little bit. 19 had a service animal that helps her with disability issues. The university had a requirement that first year and second year students live in dorms, but there was an exception to that for second year students if they were going to live in a fraternity house, an approved fraternity house or an approved sorority house. 19 was approved to move into a sorority house. She was actually one of the incoming officers the next year, and she was required by the sorority to be living in the house as well. And then what happened is this situation developed that resulted in allegations of irreconcilable accommodations between two residents of that house. So the case looks at ADA, Section 504, also involves Fair Housing Act, even though it's a college university, because it was in a dorm housing situation. So FHA rules, which may be broader, such as allowing emotional support animals, can come into play in a college dorm. So it was a long process to this because the sorority house is owned by a private, but they have to follow rules by the university. And everybody agreed that the person to try to straighten that out was the university ADA coordinator. He got involved in it. It didn't go in the manner that the court thought it should have gone to. Because what happened is after Einstein moved in, a second student, and I don't remember her name, she started claiming that she had filed with the Student Disability Office herself for having Crohn's disease and had accommodations in place for that. And those accommodations included like where she sat in the classroom and how close she could be to a restroom and some other things like that. She did not have any accommodations for having any kind of allergy. When she realized that Einstein had her service animal there, she was saying that she was allergic to dogs and that being around dogs exacerbated her symptoms of Crohn's disease. So then the ADA coordinator is trying to straighten this out between the two of them. The problem is he never asked that second student, hey, I don't have anything here that you've submitted anything to Student Disability Services Office saying that you have an allergy condition or what accommodations you need or any information at all or any supporting medical documentation. He didn't make her do that because he was engaging in this back and forth between them, trying to find a solution for this. What she did was tell him, oh, I have an allergy and it'll trigger my Crohn's. Well, when the court started looking at it, the court's like, well, I kind of question that a little bit because she's had things aggravating the Crohn's that she said was due to anxiety, but it was not anything related to a dog. It was the anxiety of starting college. It was the anxiety of when she did an overseas program and she had trouble adjusting to that and had to leave early. There was no allergy issue, no service dog issue related to that, but she was saying the anxiety aggravated her Crohn's. So now she's done nothing to produce information saying that the problem she thinks she's having this semester with increased anxiety and Crohn's is because of the dog. And one of the things he looked at, which I thought was a pretty astute observation for the court, she had claimed at some point that her roommate stayed in the room of another student at one night, and that student had been around dogs or could have been around dogs. And she thought when she came back to her own room that she triggered the allergy reaction in this roommate. But then the judge's response was, that's pretty tenuous, and there's no medical documentation to show that any of that happened. There's no factual documentation to show that happened. And I just sat here and watched Miss Einteen testify with her service dog at her feet, sitting in the witness booth. I watched her testify for a long time. And right after that, the second student testifies. She sits in the same chair. Nobody had cleaned the area. The dog was removed. But if she's that sensitive to an allergic reaction to dogs, the judge is saying, I don't see how she sat there and had no reaction at all. She didn't have watery eyes. She didn't have any other kind of allergic reaction. So he was questioning whether there was truly a connection between that, because he kept seeing other things that cause those same symptoms. And she's just unilaterally accounting it as being connected to this dog being in the house. The university had already told Ms. Einteen they couldn't accommodate both of them, and that they were going to have to then decide based on who had rented first. And the other young lady had rented first, so they told Einteen to leave. And the judge told them no, they cannot make her leave. She had a right to go back in and to be there with her dog. But a pretty interesting analysis by the judge, if you're looking at that kind of situation, to see not only what he decided, but what he looked at in the failures. Because one of the things he said was the ADA coordinator, and that coordinator admitted, had never done a valid direct threat assessment. That would have started with the girl going to Student Disability Service offices, and then them looking to see if there was anything to show that this dog was causing a reaction in the other person in the house, the sorority house. Emotional support animals in housing and service animals in housing are both allowed. The definition of an assistance animal in Fair Housing Act includes both. And so if somebody wants to rent an apartment or a dorm room or a house, and they don't have a trained service animal, but they have an emotional support animal, they can ask for that and provide some documentation. Now, when they ask for documentation in housing, please do not advise anybody to sign a release to get all their medical records. The landlord does not need that, nor should they have it. And your client should not have to pay, or the dog handler should not have to pay for an extra office visit to get it, or to pay for the record to be produced. It can get into several $100s to have that happen, and it's not necessary. What they can get is just a letter from the doctor saying, I'm a treating physician, I'm a treating psychologist, whatever, but I'm a treating medical professional, and my client needs an emotional support animal in housing to equally enjoy the use of the property. That's really all the landlord needs. And a lot of landlords will push back on that and try to get more, but that's all they're entitled to, and that's really all they need. But they are entitled to do more than ask the two questions. They are entitled to get some sort of documentation that it's needed, whether it's a service animal or whether it's an emotional support animal. There's a joint statement. I don't think this one from 2004 has been updated. There was another statement, I think, on similar issues in about 2015 or 2016, but this is still one that you can refer to, that it's basically outlining when housing situations have to make accommodations for people with disabilities generally, and that can include a service animal accommodation. Now, if the accommodation constitutes a direct threat to somebody else, then that raises those same issues. So, potentially, I guess if they had to share a dorm room with someone who had an allergy to dogs, then that would be one of those situations where the college would have to find a way to accommodate both. Put maybe the dog handler in one and move one of them to a different room where there was no dog, but still both have to be accommodated. There's some HUD guidance in 2020 that list the two, specifically list this because they use language of assistance animal, but they include service animals and support animals both. It outlines best practices. It's a good resource to look at. It also reiterates no fee or deposit for the assistance animals. And when you see that phrase assistance animals, they mean both service animal and emotional support animal. And the emotional support animal, remember, may not be a dog. All the service animals are going to be dog, but the emotional support animals could be other things. Could be an iguana or fish or something else. And it's not necessary. They in this forum where they're advising people about accommodations in this housing situation, they acknowledge that it's not required that you use specific terms, that you don't say, I'm asking for a reasonable accommodation. I'm asking to bring my assistance animal. Some landlords will say, well, they talked to me about it, but they never really said they wanted an accommodation. As long as the evidence shows that the landlord became aware that the person needed an accommodation, including the assistance animal, they knew what it was. It doesn't really matter if they used the specific language of reasonable accommodation or an assistance animal. However, in this form, they say you don't have to do it, but we recommend that you do. And I think that's a good recommendation. It's good that it's not required because some people don't know to do that, especially some 17, 18-year-old who's in their first semester of college may not know to do that, but they know to start asking for it. So it's good it's not required, but it will make it cleaner if you're the dog handler and you have to file a complaint later or file a lawsuit later. It makes it cleaner that you specifically ask it, and there's no question that they understood what you were asking for. Chavez is a woman in El Paso who had a son who had a pit bull as an emotional support animal. She lived in a duplex. And Bear owned the duplex. He worked for the entity that was the managing ownership too, had ownership of the property as well. But, when you look him up in El Paso, he owns a lot of different businesses that are housing related. And then he also is managing. So he's kind of an owner manager. And these were a duplex area in Fairview Court. Fairview Court was in the corporation was sort of involved, but he was personally named in the lawsuit because the issue arose because this woman would let her pit bull out to go into the yard, but the yard was shared between the dorm. And he really, I don't want to get value of it, but he did some things that were concerning. Let's just say that. He kept going after her about the dog. He didn't want a pit bull. It was a breed restriction issue. He didn't want a pit bull there. Breed restrictions are not allowed under the ADA, under the Fair Housing Act. It's whether the dog is trained to help the person with disability. That dog could be a toy poodle or a little chihuahua weighing 3 pounds, depending on what the tasks are, or it could be a Great Dane. Or it could be dogs people are concerned about, like some German Shepherds, Belgian Malinois, Rottweilers, Pit Bulls are a big one because insurance companies sometimes question coverage for the apartment complex for Pit Bulls. So you get Pit Bull or Pit Bull breeds raised a lot. He did not want that dog there. So he started proposing things that to me are just ridiculous. First, it was, well, you'll get another dog that I approve, a different breed that I approve, that's okay with me. And that's not his position. Or you get rid of the dog, which really was not helpful at all. He put in a couple other things that just were not work. And then he started threatening, and he was going to have the animal services there. So he's calling El Paso Animal Services 2 or 3 times, trying to claim the dog's running loose. But from what I can tell, the dog was just running in the joint yard that was shared with the other person in the duplex. So in his own yard, he wasn't running loose on the streets. In fact, one time they showed up and checked, and he had his tags, he had his vaccination, he had all the other things that were required by the city of El Paso, so they didn't even write her a citation. They just left. He kept going after her, and then he started giving her final notices that if she didn't move out by certain dates, he was going to file for eviction. They kept discussing things. Things started happening. Then he did file for eviction. I think the court initially ruled in her favor on the eviction, which is another problem with your JP court, maybe not understanding that there was an ADA issue. Because in JP courts, in those early eviction cases, sometimes neither side is represented by an attorney, or frequently the landlord's represented by an attorney and the tenant cannot afford an attorney. So they just come and try to work it out themselves. And they don't know how to explain that this is a service animal, emotional support animal. But one of the issues came up in this, it was kind of unique, is that he was claiming he should not be individually sued because anything he was doing was under the corporate structure of the management group that supervised the duplexes, even though realistically that was all him, from what I can tell. But he tried to separate out his personal liability. And the court came back and said, no, if you're acting under that umbrella of on behalf of that entity, and you're doing those things, and especially some of the things he did were so potentially seen as retaliatory, they said he could be individually liable as well. So you could collect from the business and she could collect from him as well. And he has a lot of businesses and a lot of property. So somebody that potentially you could collect from individually, sometimes you can't, but potentially a defendant that would have the money to pay. Bauman versus Elkhart is just an example of when it doesn't work. This is not telling you something that you can do to make it happen. This plaintiff had an emotional support lemur. Again, allowable. A lemur doesn't have to be a dog, could be a lemur. The city had put in an ordinance that all non-human primates inside the city were not allowed. You could not have a non-human primate. So that was broader in what it was. And some places have started putting those in after some of the attacks by chimpanzees that were pets. And so they've started trying to control that a little bit because some people have been severely injured by some primates. They asked for an exemption to that, a modification of the policy, a modification of the statute. They wouldn't do it. But the kicker is she didn't really have much of a case because she had previously lived in Houston and the lemur had attacked at one point her mailman, at one point her son-in-law. Both had been reported, both had injuries to the other person, and both of them required some period of quarantine for the lemur. And now she's moved, and there was a third incident that they knew of. There may have been more. And the court said, no, we're not even looking at this. Okay, is this lemur a valid support animal in housing? Not that. This particular lemur has already evidenced that he is a direct threat to people. And so that is a valid use of that ordinance for him. So she was not allowed to keep the lemur inside the city limit. Medical settings are different where you are, but all these different rooms where sometimes in some medical facilities, they don't think the dog can go, they actually can. Patient rooms, the clinic rooms when you go in, examination rooms, the hospital cafeteria is allowed. Blood and plasma donation centers, there's some mixed case law on that. So if that's something that you're working on, you need to do a little bit more in-depth look at your situation to determine what the situation is, who's involved, and what the issues are with the dog. They are not allowed in sterile environments like operating rooms, burn units. And those are really usually clearly identifiable. You see even medical personnel are having to take extra steps for to make sure that they're not bringing in germs to that. So it may be extra hand washing, disposable clothing covers, disposable covers for the shoes, things like that in those environments that have to be extremely sterile. Dog obviously can't go in there. This was the Griffiths cake I was thinking about before when I mentioned that, sorry. She had been going in and donating plasma at the Interstate Blood Bank, and then it was purchased or taken over by Griffiths, they had different rules about donating with service animals present. Before, when it was the blood bank, the interstate, she could go in. She went to the main donation floor where everybody was, her service animal with her. A lot of times those are large rooms with several chairs with people donating. You can also get that in a dialysis situation or other places where they do infusion for cancer and things. They could have several people in a room getting treatment in an open room. And that was kind of the situation she was in before. She had done it before. This new group had this policy that you were not allowed to do that. They couldn't bring the service animals in. They kept chipping away at that throughout the case, trying to change their policy a little bit to allow it here and there. They tried finally eventually saying she could go to another room. When the judge was like, no, you can't isolate her just because of the dog. She's entitled to come where they are because there's no sufficient showing of contamination or a sterile room. Then they started doing something that I thought was kind of odd. Okay, well, she can come in and then we're just going to waste the blood she gives because we're concerned about contamination. We'll let her give us the plasma, but we're going to waste it. So there's a lot in that case that goes on about arguing about that. But ultimately, the court found that in this situation, even though it was a donation room, other people are there, medical equipment's there, that dog did not constitute a direct threat to anybody in the room. Of course, part of the evidence for that was she had done it for years before. Under the prior administration, there had never been a problem. And there are other entities where that is the same situation that could be brought forward to show that it doesn't raise a problem in other situations. But for her, she had direct evidence that in that situation, particularly, it had not been a problem. There was no direct threat. Bingham is an ambulance thing, and this one is sort of concerning in some ways, but the whole fact situation sort of opens it up to that. Miss Nicholas was at her home and the gas had gone out. She saw a gas company truck out there and she went and said, hey, you need to turn my gas on. And he said, that's not what I do. Some other unit does that. I turn things off, but I don't turn things on. So you have to do something else. So they're waiting for this whole process. And she decided she was cold and she was going to lay on the vehicle to get warm, but she kind of spread herself out on the gas company vehicle. So I think there may have been a question, was she really trying to get warm or was she trying to cause trouble for him? But that's not real clear in the case. After the police got there, they thought there was more going on and they wanted to take her to a behavioral unit at the hospital. As they were talking to her about it, she said, well, let me go in and can I go in and take care of my dog first to make sure he's okay and all that. Then she wanted the dog to come in the ambulance with her. And that comes up frequently, especially if somebody's got their dog at, the scene of a wreck and they're taken and what happens to the dog, because you run a risk that the dog will be taken by police to a pound and then they're in the hospital longer than the waiting period for the pound or the shelter to put them up for adoption. And they could lose a very expensive service animal. So this ambulance availability can be a big deal, more than you might think it would be. It's not necessarily the sterile area, like hospital operating room. So that's not automatically going to keep them from going in an ambulance. But in this case, the court said they had an obligation to transport her safely, and that's what they focused on. And whether because of the space in there or the movement of the vehicle, whatever might come involved, that there really wasn't they had a valid argument that maybe that was not a safe thing to do, to transport the dog. They also said she didn't really show that she suffered any harm, because not that couldn't happen in some cases. I think it could happen in some cases. But in her case, they said she didn't really show that she suffered any harm. So they were not going to say that the dog was allowed to go in the ambulance with her. There's a problem with it because of some dictum that's in the case where they make some comment about also not being able to take the dog into a police vehicle. It really wasn't part of the case, but they mentioned it, I think, in a footnote or something, or just in some off statement they made, which may be something else that has to be addressed later. I want to talk just about a couple of employment cases. Employment cases are going to be very individual case specific issues because it depends on the job, it depends on the job task, it depends on the job environment, depends on the disability the person has and the task the dog performs, where you can keep the dog, is there a safe place to keep the dog and feed the dog, who can take the dog outside, how do you do that? Is there going to need to be extra breaks for that person to make sure they're taking their dog out twice a day, or can they do it at lunch? A lot of questions when you bring them into an employment situation. Unlike Title II and III, though, we're talking about a different statute because we're talking about Title I of the ADA. That may raise some issues if your employer is actually a state entity. They might have some immunity issues to Title I that have to be considered. But they are, like schools, like some other places, they are allowed to ask more than the 2 questions. So they can ask for documentation that you need a service animal, maybe some other things about the dog and how it works. That doesn't mean they can ask you for a release for all your medical records. And if you're advising somebody about that, tell them to be careful, because a lot of employers will just give a release, say, sign here so we can talk to your doctor whenever we want and we can get all your medical records. Well, they could get, with that kind of release, all your medical records from when you were in junior high school. You know, it's just a ridiculous invasion of privacy to do that. What they can get is similar to housing. Get your doctor to write a letter stating you're under treatment. Here's the things that affect you at work and why you need the dog there. There are potentially state laws that you have. In Texas, it's under the labor code, but it could be under a different kind of code in any other individual state, but it deals with employment laws, may have a different name. Those need to be checked because you may have separate protections. The state laws cannot provide lesser protections, but they can provide more protections. And often some of the state laws do provide extra protections that you need to be aware of. There are also different timelines for filing an EEOC charge for state and federal claims that you need to be aware of. So if something happens, if they deny a service animal and you want to preserve a state law claims, you're going to have to file within 180 days with EEOC or your state agency. Usually you file with EEOC and dual file it. They file it with the other agency for you. You have up to 300 days to file a complaint on the ADA federal laws or Section 504 federal laws, but we just tell people to try to file within 180 days, possible, leave all your options open if you have to file suit later. But the accommodation request or individual, when you're looking at this and it's treated like any other accommodation request, one of the things that could come up here, even though it doesn't, emotional support animals don't meet the definition of service animal, when you're talking about employment and you're wanting an accommodation, because it's so individualized and unique to that situation, potentially you could have somebody who needs an emotional support animal with them at work, and that's the accommodation they're requesting. So it's not automatically denied because they're a service animal. They're going to have to look to see if that's a reasonable accommodation in that work environment and in that situation for that particular employee, and how to make that accommodation work. Fisher versus Lansing bothers me because it's a firefighter, and there's been several firefighter cases lately. A lot of I don't say a lot, several firefighters across the country do have service animals of some sort with them, even if they're sometimes in the ambulances, they can do that. I think I personally have wondered if I see it more often because a lot of the returning combat veterans they go to law enforcement or other first responder jobs. And so some of the ones that I have seen where they have a service animal as a firefighter were also combat veterans with service-connected disabilities. This being one of them, he had combat service time and some pretty extreme service that he was engaged in. So he was requesting a service animal. They approved it locally in his station. It was approved. He was there for a long time. The problem arose when he went to another station. And then somebody else goes, what do you mean you got a dog here? No, we're not allowing that. I have concerns in the opinion because they talk about service dog, but then there's some places where he had apparently used the term emotional support animal. He needed his emotional support dog with him. And that potentially, I think, opens the door for some questions and some potential problems. So if it's a service dog, make sure you're saying it's a service dog. Don't throw in emotional support, because you could have a psychiatric service dog because they provide emotional support, but they're doing it with task. They're performing task. Refer to those as a psychiatric service dog, not an emotional support animal. It confuses the case. In this situation, he drove the fire truck. And one of the issues raised by the city was that his having the dog delayed his response time, that he would have to go put the dog up after they got the call and get there delayed. And his essential functions included quickly, timely response. His response to that was, I drive the truck. I don't have to put on all that gear. So I'm usually sitting there waiting for all the people putting their gear on to get on the truck. That was his argument about that, but there was still no change that he had to go put the dog up. The court ended up granting the summary judgment motion by the city, basically looking at that essential function, that he hadn't shown enough, that it wasn't affecting the essential function and some other things. Here's my advice about that and what I've had with other firefighters who do that. They had actual service animals, and we discussed making sure that part of the training for that service dog was to be able to self-crate with a verbal or signal command of some sort. And that to me makes a difference, because this whole argument of essential functions and delaying wouldn't even be a problem if he can give a signal to that dog. The dog walks right back to where his crates is, lays down, and stays there till they get back. They may try to raise issue about whether he's under the control. I don't think that'll fly, and in some cases it has not. But it does remove that issue of, is that dog creating a delay because he's not going to be there to supervise the dog? The dog has to be crated. Train the dog to do it himself, and you can go right to doing what you have to do to get on the fire truck. Hopman is another one that's kind of an unusual work situation that created a not helpful decision, but I think it is specific to that work situation. Hopman he was a trained conductor. Now he's an engineer. He got promoted while all this was going on, actually. He was still promoted. He was working as a conductor. Then he was deployed. I guess he was a reserve that got deployed. And then after he was serving his military time, he came back as a conductor. He wanted the dog with him. But his dog was a Rottweiler, I assume 75 to 100 pounds. I would expect it to be a pretty big dog. And where he would need the dog is on the train where he's controlling the train, which is, of course, by nature, not a wide area. And it's a moving vehicle, shifting, and other people come to get it out. So the employer and the whole railroad association got involved writing briefs to support their position, was that this was not a place where he could take a dog to do that, because they didn't know how the dog would perform in that environment. They didn't know if the dog might move and become a tripping hazard for someone. So that's kind of a bad fact situation. The interesting thing is the jury gave him a verdict. The jury voted for him and said he won and that he had been discriminated against. The judge then came back, looked at that and said, I've looked at all this evidence, and even with all this evidence, as a matter of law, there's not a violation here, and he took the verdict from him. So that is something that this case will show you, that you really need to look at the environment more and make sure that it's clear that you have taken the steps as a dog handler to defeat any potential direct threat to safety claims, either for you, for the dog, or for the other people. Now, the dog, you can kind of say, look, that's my responsibility. He's trained to handle that. But if the dog's a threat to other people walking by, or if it's a threat even to you trying to do your job in that confined area, then that may not work. So those are the broader things for employment, but just generally, employment cases are so unique. It's going to have to be each time. And if you've got a unique situation, a lot of research has to be done before you even construct how are you going to ask for accommodations, how are you going to document the need, how are you going to document the safety of having the dog there, and how you're going to take care of them during the day. Where can they sleep during the day safely and out of the way? Where can they eat safely and out of the way? How often are you going to have to take them outside? That covers kind of the general. That's a lot in a short time place. There's a lot more discussion about special rules for travel and employment issues and even housing that probably has to be considered. So this by no means is supposed to be like a full lecture on how this law applies. It's more to give you an idea of what this law entails so that you know what questions to ask. If you're trying to help somebody with a service animal, or if you are the person with a service animal, look to see what kind of questions you should ask and how you should prepare that accommodation request and how you should prepare the documentation for that accommodation request.
This direct learning session has been approved for 1.5 continuing education credits. Please note, CEs are approved from the Board Certified Patient Advocates, Certified in Family Consumer Sciences, Board Certified Case Managers, Board Certified Disability Management Specialists, Certified Family Life Educators, Certified Health Education Specialists, and Master Certified Health Education Specialists, social workers, licensed professional counselors, licensed marriage and family therapists, and also for those of you interested in just a general certificate of attendance, we also offer that opportunity as well. Please note, to obtain CE credit, you will need to select the Continue Education button on the D2L's event page from today's session. From there, you're going to be taken to a survey, which you will need to complete in order to select which CE credit you're interested in. You're going to receive an automatically generated email certificate once you follow all directions. But again, please make sure you carefully follow all prompts to receive that automatically generated email certificate. Finally, connect with OneOp to explore upcoming events, articles, resources, and more. You can access a wide range of free expert-developed resources to build your professional skills. Stay engaged with the latest insights and upcoming events by following OneOp on social media, and join our OneOp mailing list to receive webinars and continuing education information straight to your inbox.